Hi everyone, my name's Andrew Macaulay. I'm a partner and the head of the Costs and Litigation Funding team at Clarion. Welcome to this special video podcast called LASPO 8 Years On. Now, I was talking to Dominic Regan a few months ago, and we both couldn't believe it's been 8 years since the LASPO reforms. And we both thought it'd be a great idea to talk to the architect of those reforms and get his views on how they've bedded in. So I'm delighted to say that Sir Rupert has joined us on the call. And before I pass you over to Dominic, who's going to pose some questions to Sir Rupert, I thought it'd only be courteous just to explain a bit about Sir Rupert's background. So, Sir Rupert was the author of the most thorough review ever in the world of civil procedure. His 2010 report generated over 100 reforms, which of course were implemented on the 1st of April 2013. The abolition of recoverable additional liabilities transformed the costs of litigation. Cost management and the Part 36 uplift also had a profound impact. Frustratingly, we await MOJ action upon the final part of the Jackson jigsaw, fixed costs up to £100,000. Sir Rupert delivered detailed proposals as long ago as the 31st of July 2017. Wow, long time ago, with a little assistance from Dominic. While Sir Rupert retired in 2017, he is as active as ever, acted as an arbitrator and mediator from well-known chambers in London for New Square. So without further ado, I'm going to pass you over to Dominic and Sir Rupert. Enjoy.
Oh, Andrew, thank you. Right. First and foremost, so long ago, so we've got probably a generation of lawyers who don't actually appreciate all that happened. So can you just explain how it was that you got the job of having to come up with these proposals and getting this a year out of your life, as I understand it?
Well, during the early years of this century, costs were getting out of control. There was a costs war in which claimants were recovering huge success fees on top of their normal costs, and liability insurers were devising all sorts of technical arguments to shut claimants out from getting any costs at all. There were big problems over disclosure of documents and all manner of things. I was appointed to the Court of Appeal on the 1st of October 2018. The Master of the Rolls, Sir Anthony Clark, said to me, I think it was the day I was appointed, but he'd got a little job for me. He wanted me to sort out the problem of escalating costs of civil litigation. I was to have 1 year out from sitting, not set foot in court once during 2009, and was to deliver my report by the end of 2009, which I duly did. It was published in January 2010, and as the first speaker has said, it was implemented in 2013. I should just add that my work didn't stop at writing the report. I was in fact put to work doing setting up pilot studies, working groups, doing a lot of drafting of rules and so on. Then after implementation, I spent a lot of time reviewing how they were working and giving lectures when I thought things were going wrong. And indeed, as I think the introducing speaker
Andrew,
said,
yes.
Andrew, during 2017, I wrote a further report on how fixed costs above the fast track should be introduced. So, for better or for worse, it's fair to say that the reform of civil justice occupied the entire 10 years I was in the Court of Appeal.
Sure.
Obviously, I did sitting as well, except during 2009, but a huge amount of my time was simply given over to law reform.
And you travelled the world. I mean, you travelled around England as well as Australia, but you travelled the world in. Well, were there any sort of real revelations on your travels as to?
Yes. During 2009, I went round the world at your expense in order to see how other jurisdictions dealt with the problems we were confronting here. And I learned a huge amount. I got the idea of provisional assessment from Hong Kong. I got the idea of firmer enforcement of rules and orders from Singapore. Surprise, surprise.
Yes.
I got ideas about hot tubbing of expert witnesses from Australia.
Sure.
I also learned the benefits of assigning cases to the same judge throughout, from the Chief Justice of Western Australia.
The docketing system. Yes,
yeah,
yeah, absolutely. Yeah.
I learned about contingency fees or damages-based agreements in Ontario and in the United States.
And what about budgeting? Because that's a major part of
Yes.
your legacy.
Yes, budgeting wasn't operating, cost budgeting or cost management wasn't operating in any of the jurisdictions that I visited.
Mm-hmm.
There were various papers which I read mooting the idea. There was a paper I remember published by some Australian guy,
Yes.
suggesting it, not that it was ever implemented.
No.
And there were academic reports in this country. I tried to take those reports and devise a practical way of putting them into effect. And I set up a number of pilot studies.
Indeed.
Because there were teething problems with the initial pilots.
Yes.
But by the end, and by the time cost management was implemented in 2013, I think we got the rules about right.
Yes. Well, indeed, I did the Birmingham session for you with His Honour Judge Simon Brown, QC in the Mercantile Court.
Yes,
there,
you did.
And it was a great concept. And I know that, as you mentioned, there were teething problems and resistance, but I guess there is always resistance to change, is there not?
Yes, I think it's fair to say that when my report was published, it generated an outcry of opposition from all quarters. Liability insurers were extremely cross with me for proposing that general damages should go up by 10%. The ATE insurers were furious with me for suggesting that their premiums should not be recoverable. Claims management companies were furious with me for suggesting that they didn't add any value to the process. And
They don't.
which they don't, and their referral fees should be banned, and if possible, they should go out of business.
Don't pull your punches.
Claimant lawyers were furious with me for proposing that recoverable success fees should end. Judges, quite a lot of judges, were very cross with me for proposing cost management because that meant more work for them. And you've probably forgotten it now, Dominic, but I came under a huge attack from all quarters of the legal world. And when that happened, I knew I got it right. Because if some people liked it and some didn't, that would suggest favouritism.
Indeed, a partisan approach.
And also, I wasn't given a year out of sitting in court to write a report that was blancmange or motherhood of apple pie.
No.
I was put in that particular post to propose serious reforms to tackle the problems.
And they were, I mean, one thing, of course, since you retired from the bench on your birthday on the 7th of March 2017, but I mean, there's one case I was looking at recently, a clinical negligence case called just XDE, where because of your reforms, the health authority saved just over £1 million.
Really?
In one case.
Really?
In costs, yes.
That's interesting. I should correct you. I actually retired on the 7th of March 2018.
Oh, my mistake. Oh,
so I've been retired for just over 3 years.
Yes.
But I've been out of the picture during the last 3 years entirely. I better say, Dominic, that ever since I retired just over 3 years ago, I've been working as an arbitrator and a mediator. And I have also been writing some Roman history. And I just happen to have brought with me my history of Roman Britain, in case that's of any interest to your viewers.
Sure.
I said once that all the royalties are going to charity, so I have no financial interest in the book. Right. But if any of your viewers would care to read it, there it is.
There it is. And available on Amazon.
Absolutely.
There you are. So that's the secret of that. So we're now at the point, Rupert, where we've now got the next wave of noises being emitted about reform. And I. Rather from like Brenda from Bristol, I think, oh no, not again. But our new Master of the Rolls, Geoffrey Voss, he is talking about an entire tech-driven regime. Now, that wasn't really viable. I know you said to me years ago, we've got to get rid of paper in litigation, we've got to go paperless. But the idea that every single step should be executed electronically. Did that cross your radar?
Yes, I mean, I wrote a report, I wrote one chapter of my report advocating that it should be possible to issue proceedings electronically rather than trot along to the court office and get a writ stamped. I urge that pleadings should be dealt with electronically and that the trial bundle should exist virtually and be accessible by the parties. I mean, the money wasn't there to do it then,
sure,
but I was urging the proper use of technology back in 2009, 2010, because of course then other institutions were working in a paperless way. Banks were, for example, and I was certainly advocating greater use of technology. And I do welcome the powerful drive that the Master of the Rolls is now giving to introducing or making proper use of technology in the civil litigation process.
Sure.
This has been partly brought upon everyone by the pandemic.
Of course it has.
I'm now finding that the international arbitrations, which I do, don't involve catching a plane and going off to the Gulf or wherever. They involve sitting in my study and doing the case on Zoom.
Yeah.
And I understand that litigation is much the same.
Sure.
So the pandemic has given an impetus.
Sure.
The Master of the Rolls has given a strong impetus. And it's clear now that the civil justice system will make proper use of technology.
Indeed. And
one of the reforms I recommended was the introduction of an electronic bill of costs. That did happen, although that particular reform was delayed a bit, but that fits very neatly with the Master of the Rolls' current drive
sure.
for greater use of technology.
Sure. Can I ask you, there are a couple of things that also that our new Master of the Rolls has flagged up. I wonder about your take. One, he thinks that the rules are too large. And it's interesting because Lord Justice Coulson, who's taken over as editor of the White Book, says, well, the reason why we've got more rules is because the government keeps introducing new laws and we've got to accommodate these measures. So that there's this sort of issue about whether the rules are too wordy. And the other thing I really wanted to ask you about is, do you think that it is viable for people never to go back to courtroom hearings again, or do you think we should be?
I think we do need courtroom hearings. I don't think everything should be done. All hearings should be done virtually.
Good.
What I think is important is the document management side being electronic.
Surely.
We don't have to have huge bundles being carried to court every day or exchanged in county courts. But I'm a great believer in oral advocacy in court. In the last 3 years, I've had to do arbitrations on Zoom from my study at home and listen to witnesses and counsel in that context. But in my view, it's much better in arbitration to have a real gathering of the individuals, the counsel, the tribunal, the witnesses, and so forth. And I believe that in litigation too.
Yes.
I don't think we should move away from in-person hearings. The real use of technology is managing the vast piles of documents which seem to accumulate in every dispute.
Yes. And of course, you've got so much experience of sitting on the bench and conducting trials galore and then dealing with appeals in the Court of Appeal. Yeah, I always thought that the demeanour of witnesses and experts was quite a big thing, and I probably one loses that sense of immediacy, that ability to gauge the quality of
you do lose the sense of immediacy when all the individuals are looking at you from computer screens in their sitting rooms around the world. It's quite hard to define, but there is an atmosphere when you have a hearing in court or in the arbitration centre, and we mustn't lose that. We don't want to throw out the baby with the bathwater.
Here. Absolutely right. Andrew, in his introduction, mentioned what I think you regard, or you wrote about as the missing part of the jigsaw, which is fixed costs. How important do you think fixed costs would be to complete the Jackson legacy?
Well, when I wrote my main report in 2009, I said we should introduce fixed costs in the fast track, and I set out a grid for those fixed costs. And I said that once these reforms have bedded in, we should look at extending fixed costs into the lower regions of the multi-track. Well, fixed costs were introduced for personal injury cases in the fast track in accordance with the grid set out in my report.
Yes.
The non-personal injury cases did not have a fixed costs regime introduced, which was unfortunate. Anyway, in 2016, or at least by 2016, my reforms had 3 years to bed in. And so the Master of the Rolls and the Lord Chief Justice reminded me of my recommendation that after a few years we should extend the fixed cost regime upwards, and asked me to prepare a report on that topic. So I devoted the first 7 months of 2017 to that task, not working full time. The arrangement was that I sat in court for 3 weeks every month and took 1 week for working on the fixed costs reforms. I produced a report on the 31st of July recommending completing the fixed costs regime in the fast track and introducing fixed costs for the lower region of the multi-track, i.e. cases up to £100,000 where the issues were relatively simple. I forget the details, I think not more than an expert on each side, something like that.
And indeed, no longer than 3-day hearing. Yes, yes.
So I was recommending fixed costs for the more straightforward cases in the multi-track. The government were, as I understood, quite attracted to those reforms. That's what I gathered informally from the Ministry of Justice.
That's what I heard too, independently from you. Yes.
They went out to consultation on my report. I don't know what the consultees said, but we've heard no more about it. Whether it'll be introduced or not, I don't know. I think that would be a good thing. But let me say it once, Dominic, it's not the end of the world if it's not introduced. My main reforms are my main reforms. Yes. The second stage I suggested, they asked me how would we do it. Well, I've told them how I think they should do it. And it's up to the Ministry of Justice really whether they want to do that or not. I think it would be an improvement. But we can go on perfectly well, so to speak, with the present reforms, with fixed costs for the bulk of the fast track, which are personal injury cases, and with cost management across the whole of the multi-track. So I'm not losing sleep if in the end they don't extend the fixed costs.
Okay. Well, I think that takes us a perfect review of what you've done and why you did it and where we are. And I'm intrigued by your views that you don't lose sleep about fixed costs, because I heard that the MOJ were very keen on it, but then they sort of went into sort of state of paralysis, and they've certainly not rejected it. It just seems to be drifting, but at this rate, we're not going to see anything for perhaps until the end of 2022, assuming they do.
There will come a point when it might be said that my grid of costs drawn up in 2017 may be a little bit out of date.
Well, indeed.
I'm not saying it is out of date.
No.
The point will perhaps be made, well, this was a grid of costs drawn up 5 years ago.
Sure.
Is it still valid?
Yes.
I don't know.
Indeed. And
I've not been following them.
No. And indeed, the other point that comes to mind is that we're likely to see, for the first time since 2010, an increase in guideline hourly rates coming this autumn.
We are.
And because the one thing that they didn't do, which you recommended, was to abolish the indemnity principle. That still is lurking out there.
I think that was a mistake.
Yes, yeah.
The indemnity principle gives rise to all sorts of technical defences in relation to costs. It has caused the damages-based agreements reform to be underused.
Correct.
I think that particular rule, which is a highly technical rule, does more harm than good.
That's a fine point upon which to come to a conclusion. So we'll go back to Andrew now, for me, just to say see where we are. But Andrew, I hope that's all made sense to you. I mean, I'm afraid I get carried away with our chats here. Sorry.
That's fantastic and really, really great to listen to. Just a couple of observations from kind of my world as a cost lawyer. The e-bill had some teething problems at the start, like any reform does, but actually it's working really well now. And
I'm really glad to hear that.
Yeah, that's been a really positive step forward. And then in terms of cost management, again, lots of teething problems at the start, but what we see now in the team at Clarion, where a matter's been cost managed well and the cost management is obviously in place, the settlement of costs at the conclusion is obviously much quicker and much more proportionate, which obviously was the aim of the reform.
Well, it was undoubtedly one of the aims of the reform. Another aim was that the litigant should know at an early stage what the costs position was going to be at the end of the day, what they were letting themselves in for. Makes it easier for them to take informed decisions, makes it easier for people to decide whether to settle or fight, and it makes it much easier for mediators who are trying to provoke a settlement or promote a settlement to be able to say, well, look, this is the cost position you face if you lose, that's what you get back if you win, and these are your chances of success.
Yes. Takes away the element of surprise. Everyone knows where they stand. And
just more shock than surprise, I think, having harking back to Sir Rupert's report. But how much? Anyway.
And just to bring to life a real life example, one which I worked on last year, a commercial litigation matter, went to trial. I think the costs from memory were budgeted and were up to about over 300,000, so not small. And those costs settled within 4 weeks of the conclusion of the trial, because there was some costs which went over budget. We had no good reason to claim any more than the budget, and the paying party had no good reason to depart from the budget downwards. So in reality, it was fairly academic. It was swift. A lot more money was spent on the cost management, obviously. A lot less was spent on the detailed assessment.
Well, I'm really glad to hear that. Thank you for the information.
It works. So there.
Good. It works, yeah. Fantastic. Brilliant. Well, look, thank you, Sir Rupert. I know you're very busy, so I really appreciate you joining us and taking the time to talk to us. Dominic, thank you as always for
No, not at all. It's lovely to catch up.